Hello everybody, and welcome to today's webinar on navigating compliance, keeping you ahead of the game. My name is Agyemang, and I'm Global Tax Correspondent at the Financial Times. In my job covering tax, I'm constantly seeing changes to the tax law, and that's both in the UK and internationally. So I'm well aware of the difficulties of keeping up of all the different changes that are happening. I also write about companies and individuals who fail to comply with tax rules. Sometimes that's due to mistakes or lack of knowledge or occasionally avoidance. Another big topic I'm very interested in is the minefield of rules that comes with contract workers and freelancers, in particular IR35. So I know how critically important it is to keep on top of all these rules for compliance, even though that's of course not easy to do because they're difficult, complicated, and there's lots of them. And I'm sure that's something that everybody who signed into Watch Our webinar today can relate to. And hopefully we're going to do our best over the next hour or so to talk through the key and most important issues of interest to you. And also going to cover some misunderstood or lesser known pitfalls that can come up in this area. So we've got a fantastic panel today to talk through those issues, and I'm just very briefly going to introduce everybody. I'm not sure yet if one of our panelists has joined, but I'll introduce him and he can join along the way. So first I'll start with Kevin Austin. Kevin is the director at Access Financial, which of course has organised today's webinar. And Kevin has 45 years professional experience, 24 of which have been in the contract management sector. We also have Dave Chaplin, who's a leading expert in IR35 and the founder of IR35 Shield. Dave has literally written the book on IR35, in fact, 2 of them, I think. So it's great that you're here. We also have Helen Phillips, who's the founder and director of The Contract Doctor, a legal consultancy that helps startups and small and medium businesses with their business law. And we will be joined by Dr. Fabio Pineschi, who's based in Italy and is a certified public accountant and registered auditor. He supports tax compliance issues for self-employed people in Italy. And finally, we have Susanne Schorrel, who is an international tax advisor at Baker Tilly in the Netherlands. She helps companies with all tax issues involved with crossing borders, mostly from a Dutch point of view. So thank you all very much for being here today and having taken time to discuss, which I think is going to be a very interesting hour. I'm not quite sure whether Fabio is with us yet. So we're going to come back to him because I was going to ask him about the 183-day rule, but we can come back to him when he's managed to join. So Susanne, if you don't mind, I'm going to turn to you first. And really just wanted to talk to you, ask you about international remote working, because obviously you're dealing with that on a daily basis. What would you say are some of the key compliance issues you would highlight?
Yes, thank you, Emma. I'm not going to talk about the tax part, which is weird for a tax specialist, because Fabio will definitely go into the 183-day rule, and I don't want to be doubling the information. So I want to focus on a very important part, which we see is a hot topic on a lot of questions at this moment, which is Social Security. Social Security contributions are obligatory. However, if you start working remote in more countries, it gets complicated quite quickly. And it's not only important for the person that is subject to the Social Security, of course, because you do want to be insured in case something happens, but it can also have specific consequences for the employers. So, and in my daily work, I see it a lot that now due to Corona and everything, remote working cross-border is way more common than it used to be. And it could be for long-term detachment. Sometimes it's a short-term period. But you do, of course, want to know if you as an employer or if an employee or a self-employed person should take anything into consideration if you want to work remote. And I advise on this from a Dutch perspective, but of course we do see a lot of the topics cross-border, and I do have a lot of cases, of course, with the UK. We had some before Brexit, but we definitely have some after it. So it's definitely still a hot topic. So I just wanted to take a two-step approach, because I think there's, from a Dutch UK perspective, there's a separate part of rules because we have a bilateral agreement regarding social security contributions. But I also want to reflect a little bit on the EU regulations. Simply because I think from the UK, doing business with the Netherlands isn't the only EU country. So I think it's good to have some more feeling about the EU regulations. And if there's still time, depending on how quickly I go through all of it, I do have some points of attention or things that are good to know that you can definitely take into consideration. So I just want to, I think, let's start with the UK Dutch situation. We have the bilateral agreement for social security contributions. Despite all other regulations we have between the UK and the Netherlands, this one is quite straightforward, which is good to have sometimes. Now, this one is quite straightforward. In principle, if you look at the bilateral agreement for social security contributions, if you work remote, so in another country where you're residing, let's have that as remote, then you are subject to social securities in the country where you're active. So that's quite straightforward. Things might get a little bit more complicated if you're active in two countries, which we see a lot because we always say jokingly in the Netherlands, if you leave here at 7 or 8 in the morning, then you can still start your working day at 8 in the UK due to the time difference. So you see a lot of persons traveling to both countries and working in both countries. And in that case, the bilateral agreement with the UK and the Netherlands says that your social security is obligated in the country where you reside. So that's quite straightforward. And to make it even simpler, it's exactly the same whether you're employed or whether you're self-employed. So there's no difference. It does mean that if you are living in the UK and you have been working in the Netherlands, you will be subject to social contributions in the Netherlands. But if you have 1 day of work in the UK, then it will switch back to the UK. So because then the country of residence is the most important part. It does mean that it is good to take all the facts and circumstances into consideration. It also means that you can do a little planning. This is something that I do a lot. I look with employers or employees, what is preferred and what do you have to do or what don't you have to do to be sure in which country you're subject to social security. The thing is, if it's straightforward, then it's always complicated on another topic. And I think it's important to keep in mind that this is completely different than how we normally see social security from an EU perspective. We have the regulation on the coordination of the social security regulations, which prior to Brexit, the UK was also a part of, but after Brexit, not anymore. There, the regulations are a little bit different, which is important because, you do have to check which countries are involved and how does it work out. if you look at the coordination rules, so the EU rules, I'm going to shorten it to EU rules, not say the complete sentence all the time. The EU rules, you will see that if you are employed, because there is a difference in employed and self-employed. If you are employed and you have a substantial amount of your activities are done in your country of residence, then you're subject to Social Security in your country of residence. However, if you do not work for a substantial amount, and a substantial amount is, we always calculate the 25% or more, so at least 25%, so 25. But if you work less than 25% in your country of residence, then the regulations say, the current version, that you have to check in which country your employer is residing. So that could be even another country than where your activities are done. Very complicated because it's different than the Dutch UK part. And there has been changes. There has been changes in the past, and there will be changes in the future. Because again, as of Corona, we see that there's a lot of more movement across the borders. People are easily residing in another country or working in another country. It's easier to work remotely, so from definitely from a distance. So we see there's a lot of traffic, and I think the regulations and this coordination will definitely be renewed. But at this moment, this is how it works. If you're self-employed, it's the same as we used to think it was. So it's the same as employed in cases that if you are performing your activities for more than 25% in your country of residence, nothing happens. It's still your country of residence. If it's less than 25%, then it's changing to the country of the activities. So then there is a difference. In all cases, in all the regulations, it is stated that the employment always tops self-employed. So if you're employed in one country and you work as a self-employed person in another country, the regulations for the employment are first in line. So you have to take those into consideration. Is it important? Yes, as I said, it is important. Of course, you don't want employees or as a self-employed person, you don't want to be unsecured, because that could definitely be an issue. But it's also important for employees and employers, and I think that's something that's sometimes neglected or at least not seen enough. And definitely because not all contributions are the same. If you look at it from an employer's perspective, you definitely want to have your personnel, let's say in Luxembourg, because that's a cheap country, if you look at the Social Security contributions. However, if you look at it from the other part, France is a very expensive country. So it's definitely interesting to take that into consideration and to determine how it would work out. And as indicated, there is a new regulation coming. We don't know when it's yet. And some EU countries, which is also helpful to mention, some EU countries have made a new agreement that's only for remote working if you can work remotely in a IT part of the company. So normally accountants and people that can work on a laptop or a computer. It is possible for countries to have an agreement that even if you work for 50% in another country, you can still be subject to your home country. So there's definitely changes that we see from Corona. But it's an important subject, and to be honest, it's in most cases, I think, the last one that comes on the table. Oh yeah, we do have the Social Security after we have thought about taxes and all regulations, but it could have a significant impact, especially because it can harm a situation of a person if they are not secured. So in short, that was my part.
That's fascinating stuff. Thank you, Susanne. Yeah, and you're right that sometimes people don't think about that right until the end. I mean, actually, it's a big deal. So probably think about it earlier. Would you suggest that people try and think, at least not forget the social security part?
Now, definitely don't forget it now, because it comes up if something happens, if you get sick or something and you're not secured, there's no obligation or no premiums paid anywhere, of contributions paid anywhere. You don't want to find out at that moment, but it is something that's easily forgotten. And I think, and then it might be a perfect bridge back to Fabio, it's also something that is in most cases connected to how the tax treatment works, but it doesn't work the same. Because from a social security contribution, you can never be subject to social security in 2 countries, unless, of course, it's outside EU and there's no agreement. But if you look at UK, NL, or I think UK and all EU countries, it's not subject to have social security obligations in both countries. You can do voluntary social security contributions, of course, but no obligations. So it's not mandatory.
Dave, I mentioned at the start that IR35 in particular is an area of interest for certainly FT readers. And I know that it affects, thousands of individuals and businesses. So you are somebody who knows a lot about this. It is a very complicated area. What would you say are the sort of key pitfalls or key issues that people need to think about in understanding IR35?
Thank you, Emma. So I'm Dave Chaplin. I'm the CEO of IR35 Shield, and I've been in this IR35 game for over 20 years. And my company helps firms and taxpayers with these IR35 assessments and compliance. And we also help with HMRC inquiries and appeals to tax tribunals. So we do everything really, all the way from doing the assessments all the way to defending them in court. So I'll share some observations. I can hear some background noise. Does someone need to mute their microphone? So I'll share all my observations from the implementation of off payroll, what happened, and then some insights into maybe how your compliance can be rock solid, and give you a forecast of what's coming up. Now, I've been told that the audience today are people that are very familiar with IR35, so I'm just going to put some baselines in, and I'm going to make 10 points that we all kind of agree on and know about, and then we can move on to some of the meat of what's going on. So I can still hear somebody in the background talking. Sorry, I don't know if someone can mute their microphone. It's very off-putting.
Yeah, yeah. I think.
Oh, okay, it's gone. Right, okay, so 10 points about our fabulous friend IR35. So there's no such thing as IR35. It's just a label. There are 2 sets of legislation, although today we're going to be talking about the off-payroll working legislation, even if I refer to it as IR35. Both of these pieces of legislation are called they're deeming provisions, and they seek to deal with deemed employees and the mischief apparently that's been going on, where all these naughty people are disguising themselves as employees when they're not really. They're disguising themselves not as employees when the government think they are, and they should be paying more tax, and so should the firms that hire them. Third point, there is nothing in statute to work out whether someone is an employee or not. So you have to rely on decades of case law. And that's not easy. The strange thing about IR35 is everyone who doesn't know anything about IR35 thinks it should be easy to work out if someone's an employee or not, but that isn't the case. Right, so point number 4, all public sector companies from April 2017 and medium and large companies from the private sector from April 2021 need to worry about the off-payroll working legislation. 5th point, even though an engagement between a client and a worker might be classified as this wonderful phrase, employed for tax purposes only. That does not mean that they get the same rights and classifications in the rights tribunals, in employment tribunals. So in tax, we've got self-employed and we've got employed, and in rights, we've got this middle status called the called worker status. I was going to refer to it then as the little bit pregnant argument. Number 7, the tests used in tax and rights are largely the same, but there is some contention around the case law aspects. And to throw a curveball in, for worker cases, we can use something called a purposiveness approach when we're to contractual interpretation, which we don't have in tax. You can look that up. It's called the auto cleanse case. Right, number 8, key point about the tax calculations. They're different under the old rules to the new rules. Under the new rules, the hiring firm or fee payer has to pay employers NI on top of what the contractor has been paid if it's considered a deemed employment. Under the old rules, that was taken out of the contractor's money. Can't do that now. Number 9, there is the small companies exemption in the private sector under the new rules, whereby if the client is small, defined by the Companies Act 2006, then off-payroll working doesn't need to be considered. If it's the contractor has to think about the old rules and they do the assessment themselves and liable for the tax. And the last one, number 10, when it comes to liability and who's going to pay the money under the new rules, the statute pretty much steers everything back to ultimately to the client who made the status determination. The contractor doesn't have any tax liability, and that kind of aligns with the idea in tax law that the person who makes the decision, who's the decision maker, is the one who's under the cosh for the tax. Right, so I'll just break there. I've done my 10 points. Now let's go on to the impact of what happened. 2 points to make on this. The legislation, when it came out in 2017 and 2021, had a massive flaw in it. Okay. Second point is that the public sector bodies and, of course, private sector, public sector bodies were forced to use something called CEST, which is HMRC's online tool for determining status. And that wasn't really very helpful. So the flaw that I refer to is something called the offsets issue. And if you're in tax, you'll know what the offsets issue means. If the firm gets the classification wrong, so they've paid someone gross payment, what's called outside IR35, then if HMRC step in and say, well, no, you're wrong about that, then they have to pay the employer's NI bill. So this is the social security contributions type stuff. So the NICS bill for the employer's NI, and they have to pay the employee's NI, contractor's bill, and they have to pay the income tax as well, even though the contractor would have paid roughly that same amount already via corporation tax and income tax on dividends. They still have to pay it again. So we effectively have double taxation. That flaw will be being fixed, and I'll come on to that in a second. The second issue still is CEST. CEST is misaligned with the law because it uses what I've called single factor determinations when it hands out these outside IR35 decisions. And the law is very clear that that approach is wrong, and it should be a multifactorial determination that should be made. When you bake the cake, you need to put all of the ingredients in. You can't just take one piece out and say, well, that's not a cake. Okay, that's basically it with CEST. We have published a 34-page report forensically on CEST. You can go and watch it. It's for free. It's online. So what happened what was the main impact? Well, because there were these potential tax bills of 4 times more than they should have been for misclassification, lots of firms decided to blanket ban contractors. And frankly, who could blame them? Classifications were done based on averting risk rather than seeking the truth on status. Many firms did not have the in-house expertise to do these assessments, and by the time they decided they might do them, it was too late to put an assessment regime in place. We know that HMRC take 3 to 5 years to train their own inspectors on status matters because they told us that in a hearing, crikey, it's going back a few years now, the payer case with the 3 BBC presenters. So it's not something that firms can do overnight. The other thing, lots of fear of the unknown because they didn't know how to do these things. So firms were concerned about even putting regimes in place. The other big fear that firms had was that they were concerned that they would have been harboring some of these disguised employees. And if they told them they were disguised and told them the reasons why they were these deemed disguised employees, whichever phrase you want to use, there was a fear that they would be hit by loads of claims for employment tribunals for sick pay, holiday pay, and all this kind of thing, right? So that's why lots of these blanket bans happened. And so they kicked them all out and decided to start again. Public sector bodies, they relied on CEST from 2017. And because of this single factor determination, it will tell someone that they're outside IR35, even if they haven't substituted, but there might be a right in the contract. The law doesn't do that. And they got hit with £250 million worth of tax bills where they fined themselves. You know, we're sort of turning into a bit of a circus, really. What really happened for everybody was that they pressed the reset button, cleared out all the contractors, and then the dust started to settle. So we're going into dust settling mode. We've had 2.5 years of this. Firms are now lifting those blanket bans because they can't get the people they need unless they embrace the legislation. So often we get calls from firms saying, we can't do this anymore. We need to get the project sourced. We can't get the people. They're all working for our competitors. So they have to embrace the legislation. The other thing is that this massive flaw, the offsets issue, is finally being fixed. And what this will mean is that the tax bill that the client ultimately pays will be offset by the amount that the contractors already paid, so their corporation tax and dividend tax. And as a general rule of thumb, the amount of tax they will need to pay will be somewhere in the region of about 12 to 15% on top of what they've already paid the contractor. It gets a bit more than that if you're looking at contractors on 200 and 300 a day, but the more you pay someone, particularly when you go over £500 a day, the more you pay someone, the less tax risk you have, because the offsets are bigger. So let's say you have 100 contractors and you get it wrong for 1 or 2 of them, your extra tax bill to pay is going to be less than 0.5% of what you've paid to hire all those contractors in the first place. The real big worry really for firms is that they get the whole thing completely wrong. And dare I say, if you rely on CEST and just a right of substitution, you're going to be in that zone. The next thing to say is HMRC are enforcing the legislation. They're taking a 2-phased approach on this. The first thing they do is they look at the processes that the firm has put in place to see whether or not they've taken reasonable care when coming to the conclusions in their status determination statements. And if they have, and the risk is low and reasonable care has been taken, HMRC will move on to easier targets. And I can tell you, working in this zone, there are some very easy targets out there and firms that have got this very wrong. So into forecast mode, a note on the case law. I've got about 3 minutes left. A note on the case law. This is where I spend most of my time immersed in. And I've been watching hearings for years. I've represented in hearings, not represented, I've assisted. My defence partner Chris does the standing up bit, and I'm sat next to him saying, say this, say this. So anyway, we've currently got the 6 going through the courts at the moment. I won't go through the details of every single one, but the types of things that are being discussed on the case law, 4 points to make on this. The case law around status is not in a constant state of flux. It just isn't. It's largely settled down. So the second point would be to say that everyone agrees, including HMRC, that the correct way to judge status is based on the decision that came out on the 22nd of April 2022 in the Atholl House case from the Court of Appeal. Now, I know HMRC agree with this because they said so when I went to watch a red, white and green case in January, and both barristers agreed that if the case had to be remade and reconsidered, it would be done based on the decision in Atholl House. So that's from the horse's mouth. The third point is, I guess, still staying on the case law, the Supreme Court case is coming out. It's based on the referees. There's 2 bits of case law that may get some refinement. One is mutuality of obligation, and the other one is there's something going on around control. It's something called extent of control. But no one's really expecting any major surprises from this case. It might come out this month, that decision. So we're just trimming around the edges here. So the main point is that firms can totally rely on the case law to protect themselves. And of course, we all know that you shouldn't rely on the HMRC guidance because it has absolutely no legal authority whatsoever and can't be used in court. And the same applies with the CES tool. So 3 tips for firms if they're thinking about IR35. Sort your paperwork out and make sure your contracts are robust and solid. Assess everybody on a case-by-case basis and monitor the contractors when they're doing their work and gather some evidence along the way to shore up that determination to prove that it is what you say it is. Do all of that and you should be fine. Done.
Thank you, Dave. That was a real whistle-stop tour of IR35 and some really a good way of where things have been and some good tips for going forward. So thank you for that. And I'm going to turn next to Kevin. He's going to talk to us a bit about how to use companies as a foreign employer. So yes, Kevin, please tell us.
So I can talk a little bit about using limited companies as a foreign employer when you're working overseas. There's a long held an incorrect idea that using a limited company when working overseas is not permissible, or it's not compliant. It's not true. People harbour the idea that this is part declaration of income. And as I hope I'll be able to demonstrate, this is very far from the truth. So, in my view, it's perfectly viable and compliant for a contractor to use a UK or any other EU company, and I'll get to principally about working in Europe, if they observe certain key requirements to ensure that both at home and in the work country, they remain within the main terms of compliance are met. So the first thing is, provided that the contractor has the right to work in the work country, then there's nothing to stop them registering their company as a foreign employer in the work country. Now, this is in distinction to the UK, where it's very, very difficult indeed for a foreign company to register a payroll with HMRC. But in most other countries, this is possible, and generally it's not very difficult to do. So the other condition I would say is that they should be paid a reasonable market rate for the salary that they take. So the idea, which been long the norm in the UK, is to take a tiny salary and significant dividends is something that we wouldn't advocate. They should draw a living salary or a salary that they would pay to an employee, were they to find an employee who could carry out the tasks that they're undertaking. That kind of salary should be acceptable to the local authorities. And that salary will be subject to income tax and social security. I'm not going to cover the 182-day rule because Fabio is going to be speaking about that. But in most cases, if people are going to take the UK limited company or EU company to work abroad, then there's no reliance on double tax treaters. They should be paying income tax locally from day one of the assignment. Now, if the limited company turns out to have a permanent establishment, now a permanent establishment is normally created when you have a fixed place of business where you're working, but it can also more commonly, it's created when the management and control shifts abroad. So if you are the sole director of your limited company and you go and decide to work in France, then the French fisc will say you are the management and control is now in France, and therefore we're going to treat this as a taxable presence, and they're going to look to you for French corporation tax. Now, in other countries, they are more liberal about this, and they will say, well, we'd like to see you here, or we'd like to see you here for 6 months, and we'll consider as permanent establishment. And in other countries still, the more liberal view, where for up to 3 years, the tax authorities will not consider that you've created a permanent establishment. And what that typically means is no corporation tax liability in the work country, Of course, it doesn't mean that you don't have one back home. And it also almost certainly means that you need to register for VAT if your output's above the local VAT threshold. So using a limited company abroad has certain advantages. One is the reduced costs and time constraints of forming a local entity in the work country. Forming a local company, if you're intending to stay 6 months or a year, in many countries are too expensive, too involved, too convoluted, too difficult to shut down, and it's very, very hard to warrant this. Now, we will be talking shortly about contracts and liabilities are passed down by recruitment companies and their end clients to contractors. But very often, we're faced with handling, taking responsibility for notice periods for people that a recruitment company are indicating they want to be employed. Now, one of the advantages, certainly from our point of view, is that if someone is using their limited company, then there is really effectively no notice period because these people are employed by themselves. We may think this is unfair, but that is the situation. Similarly, it's very difficult for someone to unfairly dismiss themselves in their own PSC. So this kind of risk is taken out of the frame. Generally speaking, the take-home pay for someone working through a limited company abroad is very much more attractive than it would be for an equivalent employed solution. So there are several reasons for this. One example would be in the Netherlands, where it isn't necessary to pay Social Security as the controlling director of your own limited company. So if you compare that with France, where the equivalent of Social Security would be 50% of the gross pay, you can see that there's obviously a great advantage in operating through a limited company. And lastly, there aren't any equal treatment concerns because in most jurisdictions, working through your limited company effectively takes you out of equal treatment entitlements. So foreign companies opening abroad, they've got to observe the law in the work country. Now, the laws that we've got are cover several different areas, and the first one is that as I mentioned before, permanent establishments, creating a fixed place of business, and where central management and control are. This is not universally applied, but all tax authorities don't take the same view. But there is the risk that you do create a permanent establishment. You've got to watch the local regulations are, because you are trying to fly below the radar. You're clocking up liabilities in that work country, and you're not extinguishing them. The other thing, as I mentioned before, there is the VAT. If you're operating locally and your outputs are above the VAT threshold, then you must register for VAT, and you should charge them to your clients if they are in the same country as you. Otherwise, you will be using the reverse charge provisions. On income tax, if you are employed by your limited company, then as I said before, income tax is due from day one. We can't rely on double tax treaty. In the case of Social Security, the Social Security, well, we've already covered by Susanne much more ably than me, but the general rule is that Social Security is due in the work country. It is possible that if you've had established work before you've taken your company abroad, it is possible to apply for an A1, which could exclude you from having to pay Social Security in the work country. And obviously, where you're coming from a country where Social Security contributions are low, and you're going to work in a country where they're very high, this can be very attractive indeed. And lastly, you have to look at employment law, but generally speaking, the implications of this are very small unless you are employing someone in your limited company. For us, this is a rarity. So really the message is, and provided you're using your limited company and provided you're observing the laws in the work country, then you should have no difficulties at all. Now, the real problem is that many contractors and many recruitment companies feel very comfortable about allowing people to go and use their UK limited company in the hope and expectation that nobody finds out. But non-disclosure in the work country, not having a salary in the work country, as far as the local tax authorities is complete and utter tax evasion. So we couldn't possibly, we certainly can't advocate that. Now, there is a responsibility on people who are engaging contractors and recruitment companies and not to allow this, because the Criminal Finances Act 2017 placed an obligation on businesses not to aid or abet tax evasion. So if you are willingly encouraging someone to go and work abroad in the knowledge that nothing is being done to localize the company or localize the worker, then I think this is a clear breach of the Criminal Finances Act, and I think that agencies should be very careful. In summary, I mean, that is it. There it is. Using a limited company, provided you abide by the rules both at home and in the work country, is perfectly legal.
Okay, thank you very much, Kevin. You sort of touched on it in your section that limited companies, well, that's obviously very important. There's also the all-important contract signed between employers and workers or employees. And that's something that I know that Helen is going to discuss. So I was going to hand over to Helen, and after that we'll go to Fabio. So Helen, over to you.
Thank you so much, Emma. So as Emma has just kindly said, my name is Helen Phillips and I'm the CEO of the Contract Doctor. We help businesses when they hire, and we ensure that all of their employment contracts work in their favour. Now, I know what people think about employment contracts. They're really simple, and we've all had one, we've all seen one, so we can all draft one. Now, the problem is there's actually a lot of confusion around the different obligations between being a contractor, a worker, and an employee. And quite often people use the wrong agreement when they're employing all of these different kind of structures. There's even more confusion when we use a management company and what that employed solution actually means. So when you ask an umbrella company to take on the role as an employer to allow your contractor, this is why it gets so confusing, to work for your client, why should you have to care about that? So most agencies don't care about the structure. All they think is, we've got this contractor, we've given it to an umbrella company, they can do whatever they want. We don't care. All we care about now is getting our money from the client. But unfortunately, this can actually have massive contract implications, and it can leave you open to quite a lot of risk that you don't realise. So before I start, I'm going to start with very simple contract process. So you have your client, you are the agency, you have a contract between the two of you. You then have a contract with your umbrella. That is all that you have, client, umbrella. Your umbrella then has that contract with their employee. So you're actually not involved with that employee at all, and this is where the problem occurs. So your contract with your umbrella should not be a contractor agreement. You cannot place the same obligations onto the umbrella which you would likely want to play on your contractor. So a lot of people will say, we're working with this umbrella, I'm going to send in my contract. It's the contract you would normally send to your contractor. Now, this is where one of your issues is going to start. Say, for example, you have a restrictive covenant in there. It would likely be worded, you, Mr. Contractor, cannot, for the duration of this project and for a further 6 months, work directly for the client. What you are effectively saying is, you, Mr. Umbrella Company, cannot work for this client, which might breach unreasonable contract clauses. Therefore, it's unenforceable. What you want your umbrella contract to say is you, Mr. Umbrella, will ensure that the contractor does not. So you're very subtly changing that wording. So instead of barring your umbrella from ever working with any clients ever, you're putting an obligation on them to stop your contractor working for one specific client. Very, very small change. However, the first one likely wouldn't stand up in court, and the second one wholly enforceable. Now, when your contractor commences work on an employed solution, they gain employee rights. And this is something that agencies tend to forget. The structure they've now chosen gives them additional rights in relation to labour laws. Now, you need to make sure the umbrella that you have chosen to use will actually uphold these employment rights in the country in which your contractor is a resident. They can't deviate from these employment rights or the labour laws because they're going to be breaking laws. Now, this is something that you always need to keep in the back of your mind when you get your client contracts in, because you need to be constantly thinking, yeah, this is a great contractor agreement, but can I flow it down to an employee? So you have an agreement in place with your client stipulating terms and conditions of any project that you're working on with them. You then want to flow this down to your contractor, your umbrella's employee. Now, there are different ways that you can do this. You can have a separate client contract for each umbrella. So say, for example, you're working with 3 different clients. They all have different obligations. You could have 3 different contracts that you then use to your umbrella, all with different flow downs in them. Or you can have one contract and a different schedule per each client that has the flow downs in. 2 very different ways of working, both have the same output. You want to make sure that it's easy for your umbrella to know what they're flowing down to your contractor. Now, if you're using a good umbrella, they might turn around and say, this clause that you've got here, it's too onerous, it's too problematic for us, it's going to breach these employment laws. And one of these, for example, might be, as I think Kevin already touched on, a short or immediate notice period. If you've got a contractor who is working on an employed basis, it's very, very likely that an immediate notice provision is going to breach the local labour laws. So what happens if you accept this? Do you try and flow it down to your umbrella? If your umbrella accepts that, they can't flow it down to the worker. So they're going to be stuck paying that statutory notice period. What if your umbrella then declines to accept? You've already accepted with your client. So what happens? Are you then stuck paying that additional notice period? Because your client doesn't care. You've already signed their contract. Now, this is why it's really important to be aware that any umbrella you choose to work with knows the local labour laws so that they can advise you if a term you're attempting to pass down is valid. The main reason why you choose to utilise an umbrella is to ensure that you're working compliantly. So make sure that they're actually experts and they can work with you to ensure that you stay compliant. If your umbrella company turns around and says, we can't pass this down to the contractor, this is your opportunity to open up that dialogue with your client and actually gain a bit more of a relationship with them. Tell them, we've had information from our expert that this clause actually breaches legislation in this country. If they're a good client, if they also want to be working compliantly, they are going to be willing to change this clause for you. They're going to be willing to work with you and your umbrella to create this framework where you're all working compliantly. Now, I see a lot of agencies who are so eager to close a deal, they just sign any terms that they're given. They don't even bother reviewing them. And that's dangerous on so many levels. Because if you don't review, you don't know your risk. And if you don't know your risk, you can't offload it onto your umbrella and they can't offload it onto your worker. I know I'm flowing down a lot, but that is the chain of the contracts. You constantly want to be offloading these obligations and liabilities. If any clause contradicts employment laws, you risk reputational damage, you risk pain damages, you risk large values being knocked off your ultimate sale price because of the risk of potential future fines. So you constantly have to be thinking ahead. If we do not abide by this law, if I go to sell later down the line, are they going to look back? Are they going to knock a sale price off? So here are some things that you want to be aware of when you engage someone on an employed solution. First of all, legal right to work. So any good umbrella company will be doing these compliance checks, but you have to make sure that they're doing them. So you have the right when you start working with any new umbrella company to say, what checks do you carry out? And similarly, if you start doing this on your own and you are hiring people in a different country, you've got your own PAYE solution, ensure that you know the adequate right to work checks. Statutory notice periods we've covered a few times, but it's such a big one. You need to know what the statutory notice period is in the country your worker will be resident, because you need to know the minimum notice period that you need to put into your client agreement. Generally, as we've already discussed, it can't be instant termination. Maybe exceptional cases, gross misconduct. However, in general, employer, employee both have to give due notice. So make sure you know what that statutory notice period is in that country. The next two, sickness pay and maternity benefits. If your client contract contradicts this, you might not just be breaching the employment laws, it might be discrimination that you're also breaching there as well. So again, make sure that you understand what are the maternity benefits in this country. What should I be asking for in my client agreement? What is the risk if I agree to something that subsequently contradicts what that local law says? Restrictive clauses, non-competes, joining competitors. In some countries, you can't restrict an employee from going directly to the client. In others, you can. In others, the courts take a really generous attitude towards the worker. So make sure you know, what is the rule? What am I allowed to do here? What is my risk if this is breached? Payment terms. Now, in a lot of countries, paid when paid is just out of the question when it comes to an employed solution. So you might either have to push back, negotiate with your client, or you can work with your umbrella, consider how to bridge the gap, agency advance, factoring, management company advance, several different ways that you can bridge this gap. But again, work with your umbrella, work together to find that solution. Fixed penalties or third-party penalties. You need to make sure that if there are fixed penalties in there, you can actually get that money back, because professional indemnity insurers aren't going to look at a fixed penalty. That loss doesn't have to be proven, so they're not going to insure that. Umbrella companies cannot easily pass these penalties down to a mobile contractor, because they're not going to have any assets. They're not going to be able to pay this back. They're going to disappear. So again, discuss what solution works best. It might be an employed solution, it might be a contract solution, but you need to know, what are you flowing down from your client? What can you push back on? What are you liable for if they decide, I haven't got any money and my insurance doesn't cover me, so this is with you now? Many terms in your commercial contract can't be flowed down into your employment contract. So employers cannot sue their employees. If you've got, I've written here, if you have many germs, I think I meant terms there. If you've got terms that you want to flow down, you need to make sure you can physically do that. Discuss all of your options. Now, when you're working with umbrella management companies, ensure you work together so that you're relying on each other's expertise to stay on the right side of jurisdictions. They can help you. Also, make sure that you review those contracts. So my points to take away. Number one, for the love of pizza, please review your contracts. Make sure that you know what risks are in there. Number two, be fair to your management company. Make sure that you're on the right side. Make sure that you find the right solution for all parties, including that contractor, because they are important as well. I know we're flowing down all of these obligations to them, but it has to be fair to them. And number three, open that dialogue with your clients and make sure that everyone's working together. This is a relationship that you want to go on for a long time, and it will benefit all of those parties. Thank you.
That's brilliant. Thank you so much, Helen. Really, very good summary of all the potential risks and minefields there. So thank you very much for that. I'm going to move briefly onto Fabio. We've only got another sort of 5 minutes officially. So if you could try and be a little bit speedy, Fabio, I'd appreciate that. Thank you very much.
Hello, everyone. First thing, I want to thank Kevin Austin for the invitation to this webinar. And as you know, I'm a public accountant in Italy, and I deal with tax compliance services for consultants working as individuals on Italian territory. And basically, I understand that the 183 days rule applies in quite a lot of countries around the world, not only in Italy. And pay attention, because if we talk about a leap year, so if the February month has 29 days, of course the rule will become 184, because there's one more day in the year. Basically, most people don't understand the difference between being tax resident and being not resident. Most people think that if you're not resident, you don't have to pay taxes somewhere, but it's not the case, because the difference between staying in Italy for more than 183 days and not more than 183 days is that if you are here for more than 183 days, you will be taxed as a resident, meaning that the worldwide principle will be applied, and you will have to pay taxes here for all your incomes all around the world. Whereas, as opposite, if you're not resident, you will not have to bother about your house in the UK, rather than your income salary in Japan or anywhere else on the planet. Now, the Italian tax office requires basically being registered at the town hall, which means the police will come to your house and check if you're actually living there before registering you as resident. Though if you forgot to register at the town hall, but you still have a rent contract, which proves that you've been living there, it'll be acceptable, of course, in case of an audit by a tax office. Now, sometimes in my last Congress in Florence, where I deal with tax residence concept, the Congress analyzed the real case of a dispute between Italian tax office and a very famous tennis player who would register his residence in Monte Carlo, of course, to skip Italian taxes. And so he registered at the town hall in Monte Carlo, and they registered from the town hall in Italy. But then, you know, all the papers were okay. But then when the tax office started the audit, they found out that the wife and the children of this tennis player were still in Rome. And, you know, they went to Monte Carlo and asked to show the electricity bills, water, gas, and all that stuff was zero. All the bills were zero. So they easily proved that that residence was fake. So of course, the formal residence will not be enough if also the substantial residence is not there. Now, sometimes the resident status can be very, very important, especially in a moment like this, where Italian tax benefit impartial regime has become very, very attractive, because it means 70% off or 90% in countries of southern Italy of your taxable income. So basically, most of our contractors that are coming now to work in Italy as self-employed are actually benefiting of the impartial regime. This means that if you have an income of 100,000 euro, you will only pay your taxes on 30,000 if you live in Milan or Rome, or 10,000 if you live in Sicily or southern Italy. So it's very, very attractive. But in this case, the resident status becomes critical, because it is, you know, one of the benefits of the, you know, to be entitled to benefits, you need to be resident. So we don't want to be cheating here, because, you know, the fines can be very, very high then. So we don't want to take any risk about that. So my recommendation is to avoid false residencies, because you know, at one time you pay very, very little tax, but then if they catch you, it's going to be very, very not good, not a good time. And so basically, when you want to talk about residence, Italian law now, Italian government is trying now to make some adjustments to sort of align Italian law to international law. Though my understanding is that there is a lot of confusion around the world about the concept of being resident. This thing, of course, will not regard myself, because I have an apartment here in Latina where I live. I have an office here registered, so there's no doubt that my residence is in Italy. So if I have an income whenever it is on earth, I will have to pay my taxes in Italy. Though some kind of incomes will not follow this rule, because if I have a house in the UK, and I rented my house, and I come to live in Italy with my family, the UK taxman will still want the taxes on that rent. So some kind of income would not follow the tax residence of the individual. If I become resident in Italy, but I'm UK citizen, I will still have to pay my tax in the UK for that UK house I own. So this is important to line out, because some kind of incomes like enterprises, for example, limited companies, if I have a limited company in the UK and I come to live in Italy, of course, the taxes for the limited company will stay in the UK, because limited company remain resident where they have the legal address. And sometimes it can happen that there are some cases of double tax residence, and this happens really. In that case, if, for example, some countries like France, sometimes they have different, like Kevin was saying before, not all countries have 6 months to be resident. Some countries will have 3 months, 2 months maybe. So you will actually turn out to have a double tax residency. And you'll have to look at the conventions against double taxation and see in which country you have to ask for the refund. Of course, all my contractors coming to work in Italy will turn to become resident in Italy because they want to benefit of the impatriate regime, because paying taxes on, 70% of taxable income is very, 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 very attractive. And some people are coming back to Italy, they lived in America or abroad for many years, and they're coming back to live in Sicily or southern Italy, because in that case, the taxable income would be 90% off, meaning, you understand that for 5 years, I will pay my taxes on 10% of what I earned. It's a big benefit. So in that case, they will become resident, of course. They will register at the town hall. They will have an apartment for rent. Maybe they will buy a house, so they will have their own premise, and there will be no risk. But tax office will, most cases, will be chasing Italian people going abroad. So it's not the other way around, actually. But my job is actually the other way around, because I deal with many individuals coming from abroad to Italy. So basically, I deal with Italian tax compliance. And this is it, basically. I pass the ball back to you. Thank you very much for listening to me.
Thank you. Very interesting stuff. Thank you, Fabio. Kevin, I think that we're coming to you, but we're also slightly running out of time. So I know there were a few bits you were going to mention on choosing an international umbrella, and I think labour leasing too. Perhaps you could just give us your very top tips for both those topics, please.
I'll skip through these as quickly as I possibly can. Now, what is labour leasing? Labour leasing is a contractual arrangement where somebody is employed, but who provides his services to someone else. So the legal employer is responsible for paying the taxes and social security, but the control of the worker is by let's describe it as the end client. So why is this important? Well, obviously, it's become much more prevalent these days with what we call employer of record services. So because so many people working from home, so many people working from abroad, people want to engage an employee, but they don't have a company in the country where this person is working, and they don't feel like setting one up because it's complicated and expensive. And so they will go to an employer of record, and they will engage with them to employ the individual, and the individual will then be under the control of the end client and perform their duties for them, perform no duties at all for the legal employer. So it's become extremely common, and around the world there are countries where labour leasing is just not permissible. And there are countries where it is not legislated. For example, in the UK, there's no specific legislation for labour leasing. And there are 3 countries, which I'm going to touch on briefly, where labour leasing is common, and there are special rules for labour leasing, and they also happen to be 3 important contracting countries. So in Germany, and I'm sorry if I'm going fast because I'm mindful there isn't much time, we have what's called the AUG. Under the AUG, the labour leasing company has to apply to the Bundesagentur für Arbeit for a labour leasing license, and they have to demonstrate they're fit and proper people to run a payroll. They have to have the necessary expertise in employment law, payroll, and labour leasing. In Germany, the contract has to be with the end client using the services, and the employee would be paid by the employer of record, the legal employer. And in these cases, what you have to watch is that after 18 months of working in this arrangement, the worker becomes the permanent employee of the client. Now, the only way of avoiding this is obviously one is to end the assignment at the end of 18 months, or if there's a genuine 3-month break, then the period starts again. But you've got to be very careful. After 18 months, these people for whom now our legal employees will suddenly become the legal employees of our clients, and clients need to be very mindful of this. Equal treatment applies. There's no if there is no equal treatment, if we find out that an employee has benefits, they're allowed to use, say, permanent employees are allowed to use free canteens, or they're given a car after 3 months of employment, then the legal employer can be obliged to provide these additional benefits to the worker. Of course, it's going to be entirely at their expense. So, in the case of Switzerland, the law that applies is in the French part of Switzerland, which I'm most familiar with, the Loi de Location Service, or the LSE. This regulates labour leasing. It's similar to AEG in many ways. You have to build the client, the end client. If there is no end client who has a permanent establishment in Switzerland, then let's say it was an American company, but they had no subsidiary in Switzerland, then you'd have to build the American company. And it is not possible, it's not permitted under Swiss labour leasing law to engage with any foreign recruitment company. So you cannot make payments to foreign recruitment companies, you cannot take staff from foreign recruitment companies, you cannot labour lease from foreign recruitment companies. This has got to be done via a company that's registered in Switzerland by the local canton where the company is based, and also by the federal authorities if they are operating in Switzerland outside the borders of that canton, and in fact abroad. And now in the Netherlands, the regulatory background is different from Germany and Switzerland, and because there are no specific labour leasing laws, but there are laws that impinge on how labour leasing is done in the country. Now, from the 1st of January 2020, there was the Balanced Labour Market Act, the WAB, which came into force, and this made life really rather tricky for labour leasing. The government was really set against it, and we wait to see what's going to happen because this is contentious legislation at the moment, with political turmoil in the Netherlands. I don't know if any decisions have been taken, but what this law did was it was increase the social security charges for unemployment benefit for a labour leasing company. So if you're a payrolling company, you ended up having to pay more social security for your employees than a permanent employer. So that puts you at an immediate disadvantage. On-call workers had to be guaranteed fixed hours after 12 months. The position became permanent after 36 months or 4 consecutive assignments. So after that period, these people become the permanent employee of the client. Labour lease staff, again, are guaranteed equal treatment. And now, what was transition compensation, which is payment to be made at the end of an assignment, didn't start from day one. I think it started after 2 years of employment. But now, Susanne, not, but now money has to be set aside to pay to the individual from the first day of the employment. And the last one, that's not the last, but one of the major changes that really had a negative impact on labour leasing companies like ours in the Netherlands was that under this act, employers had to provide what's called an adequate pension. So an adequate pension was not an adequate pension at all, it's a very generous pension provision. So payroll companies had to give a pension which cost around 15% of the gross pay. Which would be reasonable and fair if this were true throughout society, but permanent employees aren't under any obligation to provide a pension at all. So again, labour leasing companies, payrolling companies in our sector and the whole temporary sector was disadvantaged, again, vis-a-vis permanent employees. Of course, we understand that what the rationale was. The rationale was to make it as unattractive as possible for temporary workers. But it has made life very difficult for people engaged in our sector in the Netherlands. Is there any more time, or have I used up all my time?
I think you've pretty much used up all your time, Kevin. We've got a couple of minutes.
Yeah, when you're looking for somebody, yes, it's fine if they're your friends and you like them, but I really do think that reputation and experience is much more important here. So look for a company with a solid reputation and experience in the industry. Look at their track record, get hold of testimonials, look for online reviews, and you must judge their reliability and professionalism. The other, compliance and legal expertise, you've got to make sure the company has a real good, strong understanding of the international law and regulations that apply, and also know what all the compliance requirements are. The other very important factor is what covenant do they have? Now, this game, there is no real barrier to entry. Anyone can start an umbrella company. Anyone can start an international umbrella company. But you really do should go and have a look at the company's house and find out whether this is an organisation you want to send substantial amounts of money to, whether there is any track record there, whether there is any financial strength. So you want to know that they are dealing with their business as ethically as you would like, and that if there is any problem, any sniff of any difficulty, that they are around to deal with this, and they've actually got the financial resources. So global reach is obvious. I mean, it's very difficult to become expert, as so many claim, in 125 countries overnight. It is just impossible, and it's very naive if you believe that. So you really need to look to make sure that in the countries in which you're dealing, the people you know do have solid knowledge. And it's not pretend knowledge. It's not only the knowledge of the third party they pass the work to, but when they give you advice, there is some basis on which that advice is being given to you. I think you need to look at the services and support. Do they have the capability to provide all these services that they say they do? Can they actually payroll? Can they actually run the payrolls? Can they do this tax compliance? Can they do the immigration? So just make sure that what they say they can do and what they can do are very much in line with what it is that you're looking for. You've got to see if they've got any systems, or they're just working from scraps of paper in the office. You really need to make sure that things are systematized and they don't forget important factors, and taxes are paid on time, and the correct amount of taxes are paid on time. Now, on cost and pricing structure, it is impossible to provide an excellent service unless you're charging proper money for it. So people who are lowballing, they are compromising on something along the line. And I think a responsible recruitment company should put quality and reliability ahead of price. And unfortunately, that isn't always the case.
Okay, maybe that's a brilliant point to end on then, Kevin. So thank you so much for that. Whistle again. We've covered a lot of ground today, and I've certainly learned a lot, and I hope that our audience watching has too. So yeah, thank you very much to all of you for tuning in, and thank you also to our panelists for your time. Just going to remain for me to say thank you and goodbye.
Thank you very much. Thanks.
Thank you, everybody.
Bye bye. Bye bye.
Bye bye.
Thank you, everyone. Bye bye.